to-go and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Oh! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Damn thing ain't working.
Oh! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Your Honor, this is Kenneth Singletary, 25 CF 230. Your Honor, Mr. Singletary and I have reached an impasse in the attorney-client relationship.
Okay.
As much as we have tried, we're just at a point where we cannot get past our differences.
What would you like to do, Mr. Singletary?
He wants to know what you want to do.
Sir, a conflict of interest attorney represent me, representation of a conflict attorney, sir.
What's the conflict?
Could you take a look at these documents and
I can't look at anything that the state doesn't get to take a look at.
She can look at them too.
It's the motions that he's
No,
filed.
these are motions.
Hey, don't
paperwork
I
that he's
can't hear you
filed.
if you're both talking.
These aren't motions. These are documentations of attorney misconduct, sir. I was going to let you take a look at
Well,
them.
they have to be filed then. If you're gonna pursue that, the other option is Ms. Rivers has told me that there's a impasse in y'all's relationship as attorney and client. So what I can potentially do is appoint a regional office at conflict counsel to represent you. Is that what you want?
Yes, sir.
Okay. And just so you understand, Mr. Singletary, when you're represented by counsel and you file motions to dismiss and things like that, they're a nullity. You know what that means? It means they don't count unless your attorney then adopts them.
Yes, sir. I understand that.
But also understand that an attorney is not going to adopt a motion that they don't agree they can go forward with in good faith. And I haven't read your motion. I mean, I may have read it back in May, early May, when it was filed, just because I get a copy of those things, and I have to determine if it's a attorney-client issue, and then we have to address it. But it sounds like y'all are already at the point where you want to separate ways.
Yes, sir.
So I'll go ahead and appoint the Regional Office of Conflict Counsel, and then we'll have to just set it for a new date so they can catch up at speed, Mr. Singletary. Do you understand that?
Yes, sir. I don't know who the conflict attorney will be, sir.
It should be Mr. Klein's.
Yes, sir. No problem, sir.
But I don't control who they assign to your case, but he's typically the one who handles all the cases in this division. But sometimes things change. Eyes up front, Mr. Singletary.
Yes, sir. I don't have no problem with that. I was just going to let you inform you. I've been taking classes at the county jail, and I have the dude that's wanting to speak for me. His name is Mr. McDuffie, and he's saying I have been trying to change my life and do better for
I
myself.
certainly appreciate that, Mr. Singletary, but we're not at that point where I can make a decision that would matter.
Yes, sir.
Obviously, if you were to enter some sort of plea or went to trial, and that you're talking about sentencing or something like that, then those things would certainly become an issue that I want to know about.
Gotcha, sir.
But as far as where we're at now, there's not
And I
really
have
much to
provided
address.
that information to the state.
Okay. All right, so what I'll do is, again, appoint RCC. Can you send me over an order on that, Ms. Rivers, just because it looks like when we've been putting in the clerk's minutes because of the delay in some things, not you,
Yes, Your Honor.
that they're not getting a copy of the order, so that way we can maybe send it to them via email. Otherwise, I'm just concerned they're not going to know about it until late in the game.
Put my court date off. Just let me know. When
August 27th.
Oh, yes, sir.
That's our next pretrial conference,
Yes,
like
sir.
this. And then Mr. Klein's will come up and see you once he gets notice of his appointment.
Yes, sir.
All right, thank you, Mr. Singletary.
But I don't get no copy of that, that paper.
Hello, Mr. Smith. All right. All right, Your Honor, this is Derek Smith. He's before the court on 25 CF 319, 24 CF 966, and...
All right, so this is Derek Smith. I got two different spellings of Derek, right?
Yes.
Okay. I wasn't sure if you were the same person or not. I just wanted to make sure I brought that up.
And I think he spells his name a third way. So, when I got a letter from the jail the other day, it was a different way. Your Honor, Mr. Smith, we're still working his case. We're not ready to resolve it at this time. I am going to ask for a continuance. And I did want to hand these to the state, which is copies of some of the classes that he's been doing while in the county jail.
These are my copies?
Yep,
Oh,
yep.
thank you, thank you.
All right, do you understand all that, Mr. Smith? All right, so we'll put you on August 27th at 9 o'clock, and hopefully some progress will be made by then.
Yes, sir. Appreciate it.
All right, thank you, Mr. Smith.
Your Honor, this is Derek Lewis, 23 CF 2797. I took over this case from Mr. Williams. Prior to me taking over the case, a motion and order was filed regarding evidence, getting evidence tested with FDLE. I believe we're still waiting on that evidence.
We are, Your Honor. They had to ship the samples to, I believe, Virginia for additional testing, and we got the first.
This was DNA, right?
I'm sorry, Your
It was
Honor.
DNA.
The DNA, sample of the DNA, yeah. So then, when we finally collected the DNA swabs from Mr. Lewis, those were also sent to Virginia because they had to be analyzed by the same original analyst. The last communication I had with FDLE, because also FDLE is the agency that sends it out, They told me that they were working on it. That was about 3 weeks ago, and I haven't heard from them yet. Okay, we could set it for trial, and by Monday, I should be able to get a definitive response, also by indicating probably that we have a set date for trial. They may expedite it.
It's the most backwards thing I've ever heard. Those agencies want to know what the trial date is so that they can get around to it.
Mr.
They
Lewis,
prioritize it differently, I guess, if they know that.
Well, I understand why they prioritize it at that point, but it seems to be the only way to prioritize it. And if we set trial, you start sending out subpoenas, we start summoning jurors, and so all that for them, and then by the time you get it and give it to the defense, and then we're going to have to continue it, and all those subpoenas got served for no reason, all those summonses went out to jurors for no reason. That's my concern, it's all the extra effort that has to go into it just to convince them.
I was asking to keep it just for Monday, Your Honor. For Monday, then would be, say, trial or continue.
Okay.
That's fine, Your Honor.
That would be fine for you? Yeah.
I mean, I know the samples were just taken in February, March,
Yeah.
but this is a very old case, and I'd like to get it resolved. So we'll keep it on 6:30 as trial or continue?
Yes, Your Honor. And just for the record, because this wasn't, you weren't presiding over this case in the beginning, this was a defendant's request that we send the DNA for analysis.
Oh, I understand.
Yeah. No, I'm just, it's not the state.
I think I was aware of that. I'm the one that signed the order on the buccal swabs that were just from February.
Yeah, I was talking before when we had the whole motion on having the state submit the DNA.
Okay. All right, so Mr. Lewis, we'll see you back on Monday and see if they've made that progress and we know what the DNA says.
Your Honor, this is Diana Malone before the court on 21 CF 923. If you will recall, we were waiting on Dr. McDonald to conduct her evaluation. We had filed intent to pursue, not guilty by reason of insanity. The state asked to have their own expert come and do an evaluation. I did receive a copy of the evaluation from Dr. McDonald indicating that she believes that she would have a good defense for not reason.
GRI.
Not guilty by reason of insanity, end of the day. So, in speaking
I'm
with
not sure we're close to the end of the day yet. So.
In speaking with the state, and you correct me if I'm wrong here, the intent was to ask the court to find her not guilty by reason of insanity and then have her do the services that would be
The conditional release plan.
conditional release plan.
Yes, Your Honor.
Well, I haven't seen the reports. So. Well, this may be more of a Monday issue then. There should be two, right?
Well, the original one was already filed previously, and then this,
That's correct.
we just got it Sunday night,
Yes.
I think.
When was the first one filed?
Months ago, Your Honor,
Yeah.
when it was Mr. Williams' case.
Maybe January or February when we got the first one.
I just don't see it. That's why
I'm sorry, Your Honor, you
I don't see it filed.
Neither
so.
one?
Well, if this one just came in Sunday, it's certainly not
Right,
going to be
it's
in
not
there.
going to be there.
Your Honor, I can make
I
sure we have it on the
recall
30th.
we talked about coming back as competent, and then this was the next step, but I don't have any of the.
Your Honor, I'll make sure you have to report on the 30th.
And having reviewed the reports, did they address services?
No, Your Honor, only that it that she needed the services and that medication compliance is very important.
Okay, I'm just concerned about placement.
That did come up in Dr. McDonald's report, that she believed that she could reside with family. But that was in speaking with my client. I don't believe there's been any contact actually made with family.
This says does not meet criteria for involuntary commitment, but also is appropriate for conditional release. Okay. Well, if y'all could send me the other report, I'll take a look at it in advance of June 30th and determine, or at least
Yes, Your Honor.
have read it, and I'll listen to your arguments about anything on June 30th.
Yes, Your Honor.
But just make sure you send that to my assistant.
Will do.
Unless I'm missing it here, but I've looked through several times and I don't see it.
I agree, Your Honor. I don't see it either. I do remember maybe defense shared it with me via email because of it's a confidential report, but you're right, I don't see it on. I see they shared confidential, and then the notice of intent to rely on defense of insanity.
Ms. Malone had indicated she has one daughter in Georgia and one daughter that lives here in Okaloosa County. She didn't have the exact contact information, but we'll see about what we can find on that.
I think
Because that
if the
would
court were to
need be
consider
needed for the
that,
conditional
I'd have to
release
know some
plan.
real information about how that's going to work because, I mean, I've read this case. It's certainly concerning behavior. I understand the differences now between 2021 when this case originated and now, but that's certainly a concern.
Yes, Your Honor.
All right, so we'll see you back June 30th.
So that's next week. All right, thank you.
It's just next Monday.
Your Honor, this is Jared McCallum before the court on 24 CF 2665. Your Honor, I plan on filing a motion to suppress on this case number. I'm going to file it and then I guess have it for the 30th if there's any room available on the 30th.
Motion to suppress in less than a week?
I'm sorry, July.
The
July.
31st?
Sorry, yes, July
Okay.
31st. No, I got to give the state time to send out subpoenas.
That's why the 30th threw me off. But it hasn't been filed yet.
No, Your Honor.
And does Mr. Williams have one of his cases too?
He does have another case, Your Honor,
I just don't want to send him back just to bring him
Yes.
back out later again.
and I believe that's a 25 CF case number. And Mr. Williams and I spoke about this on Sunday. I will take over that case as well.
Ms. Rivers, I'm sorry, I was trying to locate the file. The motion to suppress you're going to file is on 24 CF or the other one?
Yeah, the 24 CF, the gun.
Okay. I cannot do the 31st of July. No.
Why don't y'all get it filed and see if we can't find a date?
That's fine, yes, Your Honor.
And again, I'd say it's looking like we've got a lot more trials than we've had recently, but then again, we've had a couple dozen set at this point before and had zero. So, but if those dates open up, y'all can potentially use one of those if we know in advance that we've got that time. I'd just rather not put it off till an August hearing if we don't need to. Put it for August 27th right now for pretrial. Let's get a motion date earlier than that if possible.
Let's get your 25 case number addressed as well. Is the 25 case number set on the docket?
25 CF 750.
And Your Honor, if we
Also
could,
set for today.
if we could have both cases put on the next pretrial docket.
827, 9 o'clock.
Right.
Thank you.
Jay Williams was not showing up under him. Oh. What are we doing with McTeer today?
He's right there. You're good, sir.
Ms. McTeer, I'm just grabbing your report.
How you doing today, Judge, sir?
I'm doing well, Mr. McTeer. How are
Blessed,
you?
sir. Blessed. Yes, sir. How y'all doing?
My understanding, we're here for basically a pretrial detention hearing because of a paperwork snafu that didn't get it on the docket for Thursday last week.
That's correct, Judge. That's
I didn't want to go past the deadline for having the hearing. So here we are. Who's handling this for the state? Mr. McTeer?
Yes.
He was the one that, when we were in court last Thursday, we were informed that he had a first appearance the day before, but the paperwork never got sent to anyone. So he wasn't set for a pretrial detention hearing. And if I had waited to put him until this Thursday, that would have been past the deadline to have that. So that's why I wanted to have a day a little bit earlier to find out exactly what we can do.
So, Your Honor, well, I will be filing a motion for pretrial detention because I just spoke with the investigator. Currently, he was emailing me. He's still preparing the report, the full report, and he hasn't submitted it to me yet. We did try to reach the victim, but the phone numbers that we have for the victim are not working. We got the phone number from the victim's mother, and right now I'm in court. I don't know the status if they were able to contact the mother.
Mr. McTeer, just face up here, please.
Yes, sir. Yes, sir. Yes, sir. I'm sorry.
That's the latest information I have. If he needs to be given a bond, I will be filing for the motion based on what the investigator from Crestview PD told me.
All right, Mr. Williams.
Judge, we don't have one yet. I understand the snafu with paperwork not getting over due to the changeover in the clerk's computer system. But
I'm not sure if that's why there was an issue, but it was certainly where we didn't get the paperwork from the clerk and anybody who normally gets these.
well, and it was short. It was the day before. But Judge, we don't have a motion for pretrial detention that's filed, so I'm going to ask for a bond. I went out, saw Mr. McTeer, spoke with him, did my end on getting prepared. I've already instructed him he should expect a GPS unit with an exclusion zone, and explain to him how that works. But I'm going to ask the court to go ahead and give him a bond.
Ms. Leone, if you haven't filed one, one of the compounding issues is Mr. McTeer, according to the paperwork I've seen, refused his first appearance and was removed from first appearance one day for being disruptive. So he's actually been in jail even longer than when his first appearance actually occurred. I think he had been there several days at least before he had a true first appearance, but the paperwork indicates that that was attributable to Mr. McTeer.
I'm seeing 0615 for the refusal, and then another refusal 616, but
Ultimately on 6/17, which was last Wednesday.
No.
Not Tuesday.
Right now.
He was to be he should have been set for last Thursday, which is what appears to be Judge Mason's signature from first appearance says 6/19 at 12:30 PM, and we didn't get the paperwork until about 2 or 3 o'clock that afternoon.
And again, Judge, we're certainly willing to comply with reasonable conditions designed to protect any alleged victim, but need to get a bond set on.
Your Honor, the record of first appearance shows that the state it's in writing, state requesting pretrial detention hearing. So can't
I
we?
guess that was a week ago, though, and you all haven't filed one. I'm sure it's because y'all didn't get the paperwork either, but that's why I especially put it on this date so it could be resolved one way or the other.
Yeah, I got it this morning, the paperwork.
Okay.
That's why I'm not prepared.
Well, we talked about it on Thursday.
I just didn't, I know, I didn't have it. My office didn't have it.
My concern is even if I granted a continuance to the state, that can only be 5 days. So I can't even put it for next week.
We cannot put it for this Thursday? I can file it right now. I just go based on.
Put it for this Thursday, but as we've talked about, Judge Clark is covering my
Yes.
pretrial detentions on Thursday.
My officer is available for that day. That I know.
Judge, does that still keep us within timeframes?
I think it does. Because I'm considering this his first pretrial detention hearing today that was set within the 5 days as required. And the state's asking for more time. That has to be done within 5 days, and we're talking about doing it in 2.
Yes.
So I think that complies with the rules, but I think it's the only way we can have it that complies with the rules. Otherwise, we're talking about next week, and I think we might be past that deadline if there's not a hearing before then.
Yes, sir.
I can have the motion filed by the end of the day. Obviously, because of the issue with benchmark and e-filing, I will send an actual copy to the court and defense counsel.
Okay.
And we can set it for Thursday at 12:30.
All right. So, Mr. McTeer, your hearing is going to be Thursday. It's 2 days from now.
Yes, sir.
But it's going to be in front of Judge Clark because she's doing pretrial detentions that day.
What is that?
You're just going to have a different judge for the purposes of this hearing.
Sir, I don't really feel comfortable with that because I didn't. This is.
Judge, I do have, Judge, what he's indicating is that he's willing to waive any time constraints so that Your Honor can hear it next Thursday. Are we still doing pretrial detentions on, is that going to be July 3rd?
Yes.
I know our office is off except if we have court. So it was going to be my turn to do it next week anyway, so I'll be here anyway to do it. I mean, we're going to have to have somebody here for sure pretrial detentions anyway, Judge.
We did, we already have some, I don't know.
I don't know.
All right, Mr. McTiernan, I just want to make sure I understand what you're asking for. That's clear. Hold on.
Yes, sir.
So what I've advised is because of the paperwork issue, I specially set you for a Tuesday today. The state needs more time because they just got the paperwork so they can even try to draft a motion. To be honest, I'm not even sure a motion's required. This is a first-degree felony, isn't it?
I don't know if it's a first year, is it a
But they have
first?
to have their people here. Mr. McTier, if you turn around and make contact with anyone in the audience again, we're going to end this hearing.
I'm just sorry, sir. I got a family. This is not me, sir.
I understand that.
This is
So
not-
I want to make sure you understand what I've said I was going to do, and what your attorney has suggested is that you would like to continue the case even farther out to make sure that I'm handling your case as opposed to a different judge.
Sir, I would like a bond, sir. I got kids out there, sir.
I understand.
These people doing with this stereotype that's done been placed on me, sir. I don't.
So what can happen is there can be the pretrial detention hearing on Tuesday. If the judge determines that you're to be held, then you're to be held, based on the determination that has to be done under 3.132, which is the rule about pretrial detentions. If the judge determines that you're not to be held pretrial detention, then you'll be given a bond.
I don't
know what that bond might be.
I won't be placed in front of nobody that's gonna stereotype me or know something, because this is some serious stuff, sir.
Well, I understand. I'm not sure what stereotype you're talking about and why your concern is, one judge versus the other.
You just sent me to prison for 12-1, sir, so you noticed my record. You said, sir, I will never, when I just did 12-1, I came in front of you, sir.
When was that?
And this was like last year, sir.
It wasn't that, then it wasn't me.
Judge. This is Judge Oberliesen.
I just know that this is not me, man. I don't do that.
That just wasn't me. That's why I'm not.
Yes, sir. I don't want to be in front of nobody that's going to try to hinder me because of
so you understand, whoever gave you 12.1 last year will not be handling this case, because I've taken over this division since then, and we're talking about another judge in the south end just to handle your pretrial detention hearing in 2 days. To be honest, I was kind of trying to figure out why you wanted me to handle it so much versus someone else, because I don't think we've ever met.
I feel as if, sir, all this whole thing is nothing.
Well, I understand that, Mr. McTier.
For Crestview Police Department to get
Mr. McTier, let me just explain. The judge at first appearance found probable cause that you've committed this. Doesn't mean you're guilty, but that's enough to get to this point where there has to be a pretrial detention hearing or not. And if there's not to be a pretrial detention hearing, or the state isn't able to prove sufficient evidence to have pretrial detention, then a bond will be set. But these rules are brand new. The rule became official May 1st, so I've got to make sure they're being followed. So there's a little bit of issue with people just being ready to handle those as quickly as they need to be, and we're just dealing with some slow processing issues
So
right now.
that explains the fact that why they brought a drug task force to my house, but I ended up in here on this type of charge.
I don't know anything about that, sir.
All right, sir. Well, then I just need a bond, sir. Thank you, sir.
Well, that's not going to happen today.
All right, sir.
So, your options are, hold on, you can have a pretrial detention hearing in front of Judge Clark in 2 days, or
Yes, sir.
that's what you want.
Yes, sir.
Do you want to hear the other option?
Sir.
The other option is what it sounded like your attorney was asking that you wanted, was to continue it another week till next Thursday, which would, next Thursday, which would be July 3rd. And then it would be me determining your pretrial detention or not.
Which judge hears it?
I'm sorry, while they're discussing, I was researching the statutes that he's being charged with. Right now, they both are first-degree felonies, as you mentioned, the first 2 counts, the kidnapping and the sex battery. So I wouldn't need to file a motion, just a request.
You wouldn't need to, but at the same time, again, this is what I think is the gap between the new statute and the new rule. Putting him on notice as to what the grounds are for the purposes of pretrial detention. I think there still should be a motion, but.
I'll file it, Your Honor. It's not-
His mothers are here, so I said about all that. I got kids with the mothers here. I don't need none of that on me. I know
All right.
fight this.
Mr. McTeer, would you like to make a decision? Do you want it this Thursday or next
Make it,
Thursday?
sir.
Judge, can we approach real quick?
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right. This Thursday or next Thursday, Mr. McTeer?
Thursday, sir.
This Thursday?
Either one, sir. Mr. Williams.
Okay. All right, so we'll place it for 2 days from now. That's going to be June 26th. That'll be in the Fort Walton Courthouse at 12:30 in front of Judge Clark.
Yes, Judge.
Oh, I have to go to Fort Walton.
Well, they'll transport you.
Yeah, the jail will transport you there. It'll be down in the, her chambers are down, or the courthouse that she works out of is down in Shalimar.
But what about the one that's here? I like Crusher.
All right.
And it'd have to be next week.
All right, next week then, sir.
Okay.
Yeah,
So
that's too long to ride. I don't even like sitting on the bus that long.
So you'll wait an extra week in order to do it in this courthouse.
Yes, sir. I guess I got to. I don't know. That's y'all world. I guess, sir.
I'll just say, let's set it for this Thursday. I don't think it's a valid decision that he
I don't
likes
want to
Crestview.
ride. I don't like getting on this bus. I want to bond out. I want to.
Well, you're not going to potentially get a bond until you have a pretrial detention hearing. So you can either they'll transport you to Fort Walton on Thursday, or you're going to wait an extra week to do it here.
Claustrophobia, and I don't like to be.
Judge, based on what he's indicating to me, I'm going to ask that we pass it until next Thursday.
This long.
Well, I understand, Mr. McTeer, but you're choosing the option that keeps you in jail longer.
Sir, it's a week. I've been in here a week. But as long as I get this put behind me and brought out to light, I don't care. I want to get all this put behind me in the light and brought out to the light, the truth, all this shit. Sir, right now, sir, I just don't want to be and nobody else judged by nobody else, sir. Because it's like I'm talking to God, and I'm not,
Well, so I appreciate that. I think you're
yes, sir.
overdoing it a little bit.
Yes, sir. So can I do? I'm ready.
All right, so we'll set it for next Thursday, July 3rd at 12:30 here in Crestview at the defendant's request.
Thank you.
Thank you, Judge.
All right, thank you, Mr. McTeer.
Your Honor, this is
That might be
Shane.
my biggest promotion so far.
Your Honor, this is Shane Morrow, 21 CF 2674, 21 CF 2998, and 22 CF 273. I've met with Mr. Morrow a couple of times now. We're still working on issues regarding the case. If you will recall, this is something that was sent back from the higher courts. He has he has VOPs, and he has new law.
Which came, here it is.
Sorry, what's that, Judge?
I was just looking for the DCA paperwork.
Judge, this is the one where they felt there might have been a conflict with his attorney, so they allowed him to withdraw the plea.
And that was that just in the first case?
That was in all the cases
All
because
of
the
them,
sentencing was as to the 2 new law violations and the VOP. We brought that over from Santa Rosa County.
Mr. Morrow had indicated that there was 2 people that still needed to be deposed on one of the cases. We're still trying to work on deposition dates.
Mark Brown and David Raul.
So, Your Honor, we're going to request the 825.
Okay, I just want to make sure that we know what the last things are that need to be done. Y'all are going to want to depose Brown and Raul. What case is that on?
The 2 are almost intertwined. Mr. Morrow was engaging with several chatters during the course of the same op. So it's both of the new cases, I would say, Your Honor.
And are those law enforcement?
They're both law enforcement, yes, sir. One is FDLE, Mr. Brown, and then David Raul is an investigator with Santa Rosa County. He was acting as a chatter.
Is there going to be time to get those depositions done between August 27th and now?
Between August 27th.
Now and August 27th. Sorry, I kind of did that in reverse.
We can certainly try to. Especially since if Ms. Rivers doesn't object to doing them by Zoom, we certainly can make them happen since they're both out of county, but that'll be up to her, of course.
I have no problems with doing them by Zoom.
And I can too. So we can do it.
All right, August 27th. I'd like for that to be the last continuance. Anything else, Mr. Morrow?
No, sir, not at this time.
Okay, well, when you say not at this time, that's exactly why I'm asking. I want to make sure we don't come back, those 2 things are done, and now there's something else that needs to be done.
We're still working through the process, Judge, and speaking with him, he wants motions filed, so I don't realistically see us being able to go to trial in September, based on my discussions with him.
Well, I don't know what motions we're talking about because they haven't been filed. So we'll address that on August 27th, I guess. We'll see you back on that date, Mr. Morrow.
Yes, sir.
All right.
See you beforehand.
Oh, yeah, absolutely.
Okay, yes, ma'am.
Always have to tell me what kind of questions they want. Your Honor, this is Kenneth Osborne. He's before the court on 16 CF 1542. I've spoken with Ms. Basso, and, Your Honor, we would like to try to set this for September for trial. I talked to Ms. Basso about any motions that we may have outstanding to get them done beforehand. I know that she will not be available on July 31st, and she's also indicated to the court she didn't want anything on August 7th. But I believe there's a date later in August that we could shoot for.
Also, ma'am, there was the issue with the videos from the prior attorney.
Yes.
That was,
Yes.
Your Honor, there's something that's set right now for July 3rd. Is that something we could address now? It was just, I believe, for the court to sign an order for the prior attorney to turn over any and all videos that he might still have.
I guess I'd like to find out from him if he's going to say he's got it or not. I mean, the issue is Mr. Osborne says that the video he's seen from you now is not the same that he was shown by his previous lawyer, right?
Correct.
that the prior attorney did indicate he would be glad to comply with the court order.
As long as there was a court order.
I believe that's what Ms. Rivers represented to the court, and so I think that's all we were
I
waiting
don't
on.
recall that. Then Maybe that's where I missed the boat there.
So we probably don't necessarily need the hearing on the 3rd if the court is willing to issue that order so that the attorney can receive it and hopefully comply, and if there's any issues, he could let Ms. Rivers know. And if we need the court to re-engage, we can. That way we'll keep ourselves moving forward, and that should allow us to also hit the September court dates.
Mr. Moore had indicated that if there was any trouble getting service on him, that we could serve his brother, who is also a local attorney. And so that's why I put it in the order. Because Mr. Moore had indicated that he frequently goes out of town.
Does he need to be served with it? If he's agreeing to do it?
We have to make sure that he gets notice.
Okay. You can't just email it to him or something like that? Or is he saying that his brother may have the ability to find and extract this video and send it to you?
No, sir. He was saying that his brother would be able to get in contact with him. Mr. Moore had indicated that all of his previous clients' files are all in a storage area. There's no particular order to them, and that it will be an endeavor. And absent a court order, he said he would comply with a court order.
File a motion, or you just send me an order on that?
It's something we brought up last time, Your Honor. I had not filed anything. We had brought it up at the last pretrial conference. Because I had been unsuccessful in being able to track down Mr. Moore, and phone calls, we were none able to get in touch with each other, and then I happened to see him that one day, and so that's the first thing I brought up to
I
him.
think that's the funny thing about it, is I think I see Mr. Moore more often now than I see him when he was in the courtrooms, because I seem to run into him in a lot of different places for some reason. Just restaurants and things like that.
And I don't. So I just happened to see him after I've been down doing a deposition with Miss Basso.
All right, well, since you're conveying to me that he's told you that he's willing to do it if he gets a court order, I've got the court order, it just doesn't indicate that, so maybe I missed that when it was talked about previous. So I've signed the order.
Thank you, Your Honor.
So, Your Honor, there's no hearing then on the 3rd, correct?
I don't know if it's already been handled.
Thank you. We just want to make sure so nobody misses anything.
Okay.
And then
That was the only hearing set for the 3rd?
On this, Your Honor, yes.
On this case?
So, September trial?
Didn't she say there was an issue with the September trial? Or was that on Mr. Morrow?
That was on Mr. Morrow, I believe, Your Honor, because she wanted some additional time to go
All right.
over potential motions.
All right. Ms. Rivers, August 27th at
Yes, Your
9
Honor.
o'clock, and we expect this will be a trial next time?
That's correct, Your Honor. Don't you have a miscellaneous date somewhere around in that time frame?
In August?
Yes, Your Honor.
Of August 7th, which I think Ms. Basso has
Trying
an
to
issue
avoid it?
with.
Right.
That looks like about it. Wouldn't be till September, I mean, July 31, but we've put a lot of things on that recently.
Is she
But
not
if-
available for that date?
I think that's right, you're not available.
Literally that 1 week I'm gone, not available.
Could we maybe put it on the August 28th? That way we could still plan on going?
He's has set for.
That's
August
after the
27th right
pretrial.
now.
That's the
No,
day.
but I mean for any hearings.
Oh, yeah.
Well,
we can-
file any motions and
Yeah,
then
and
set
then
them
we'll
for
get a
that
date
date.
Okay.
I know that the court has that listed as an arraignment date.
You know me, I'm a glutton for too many cases on the docket.
Thank you, Your Honor.
Right.
Because we would like for this to be resolved.
Me too.
Your Honor,
Yes, sir.
I thank you for your patience.
I'm not sure I have much left, but you got some of it, Mr. Osborne.
Thank you, sir.
All right, have a good day.
Be back out to see us.
Have a blessed day.
You too.
I'll just stay here.
Your Honor, if I could have just a moment with him. Your Honor, could we put him on for Monday? I think we've reached a resolution in this.
The offer remains open till Monday.
All right, June 30th, clear continuance.
That's correct, Your Honor.
See you back on Monday, Mr. Porter.
Okay, I'll write it up.
You say Robinson?
Yes, Your Honor.
Okay.
Rocky Robinson. Your Honor, this is Rocky Robinson. He's before the court on 25 CF 404. We have depositions set on this, I believe, on August 12th. We are requesting continuance to the next pretrial conference.
All right, that'll be August 27th at 9 o'clock for the next pretrial. Be back on that day, Mr. Robinson. Thank you.
Your Honor, before the court is John Frank Saber. He has two cases, 25 CF 866, 25 CF 813. Filed a motion to set bond on 25 CF 813. I had spoken with the state. We don't have discovery on either case. There's no information on 25 CF 813. He indicated to me that he believed that he had filed a dismissal on 25 CF 813.
No, I have not filed it yet. I'm dismissing it in court today, Your Honor, on 813. Insufficient evidence to prove beyond a reasonable doubt, Your Honor. And as far as 866, discovery is en route. I just verified that.
813 was dismissed, or 866?
813 is dismissed, Your Honor. State is moving forward with 866.
So what's his bond in 866?
It's 39.
I'm looking at it, looks like a total of 3,000 cash or professional.
Yes, Your Honor.
I think if I'm correct, you were looking for the bond in 813.
Correct.
Because there was
That
no
case is
bond
dismissed, so.
Correct. So it makes it moot.
All right. I didn't know if you were trying to address the other one, so.
No, Your Honor.
All right, so I'm looking at $3,000 cash or professional. That was set at first appearance in the 866 case.
So, Your Honor, we are going to request a continuance to the next court date.
The August 27th, 9 o'clock. If Ms. Rivers, if he bonds out and you want to ask for him to be moved to the 25th to be on the non-incarcerated docket, you can certainly do so.
Yes, Your Honor.
Okay, just let me understand. Thank you, Ms. Rivers. Thank you, Judge.
Thank you, sir.
Yes, Your Honor, he's in state prison.
Didn't we try to have him transferred twice now?
No, Your Honor, that's not the one.
I'm thinking
This
the
is
other
the,
one.
this is the one that 23 CF 936, he's serving life in prison.
I've got that part.
And the state wanted to continue to determine whether the autopsy results were going to show whether she was going to change the charges.
We don't have the result yet.
Okay. Isn't this from 2023?
Yes, Your Honor.
What's the delay in the results? The 2023 case, what's,
About the victim, Your Honor? Is that what you're... The victim, he wasn't originally charged with murder, but eventually the victim died, and we're believing that it is as a result of the incident, and we're waiting for the autopsy to determine if to charge the person.
I understand. So
Yeah.
the victim passed while the case has been pending?
Yes, yes, Your Honor, yes.
That's why I didn't understand.
Yes,
Okay.
yes.
And do you have an idea on how long that could be on those results? Okay. 8:27, 9 o'clock. Are you going to try to have him transported, Ms. Rivers?
Not until,
Because, yeah, if we get the autopsy and we determine that it's not related to the incident, we'll dismiss the case.
we had already done one round of depositions, but the key players being the victim, we could not find, and now we know why. And then the other person that was alleged to be there, no service on her either.
All right, August 27th.
Your Honor, he had made a counteroffer. I just
Hold on just a second.
Sorry.
Can you re-announce that?
Your Honor, we're going to ask to put this on for 6:30. I believe we've reached an agreement in this matter.
All right, so
For plea.
We sure of plea? 6:30 for a plea
Yes, Your Honor.
at 9 o'clock. All right, thank you, Mr. Simmons. We'll see you on Monday.
Your Honor, this is Davon Smedley. He's before the court on 22 CF 2688, 25 CF 502. I believe we have depositions set on 25 CF 502 for August 15th. So we're going to request continuance to the next court date.
All right, you understand that, Mr. Smedley? August 27th, 9 o'clock for the next pretrial. It's the first time up.
Okay.
Oh, here.
Hello there. Did you want? so. Judge can't.
Too much.
The 120 is what I'm working on right now.
That's correct.
And as of July the 4th, I'll have 15 days left. What day is that?
Here's all of that. Your Honor, we've reached an agreement, if I may approach. This has got all your other case information, too.
When did they give me the 90 days on the second one?
1321 is the one that gave you the 120 days on.
Are there guidelines, Ms. Rivers?
Yes.
Do you have them, or?
No, Your Honor, this is not guidelines.
They have guidelines on Mr. Spivey?
Yes, Your Honor.
Okay.
I'm just writing the date. It is a downward departure, though. But he scores a minimum 28.42.
Oh, you're fine. I've already seen it.
Yes.
This is all yours to keep.
The statement its obligations under Marcy's law regarding this case.
To contact the victim. The victim
on the
is the
second
daughter.
one.
Yes, Your Honor.
The victim is
Is his daughter.
his daughter. I think you said
Yeah.
is a doctor.
No, he's his daughter, and I've been in contact with her from the very beginning of the case. Her concern, she's very concerned about her father's well-being, but she's also concerned about their safety. She believes that Mr. Spivey could use some alcohol rehab because he seems to be affected by alcoholism. Other than that, she wouldn't want him to be incarcerated.
Mr. Spivey, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, sir.
All right. And you're here in 25 CF 504, charged with aggravated battery with great bodily harm, which is a second-degree felony punished by up to 15 years in state prison. Also resisting an officer without violence, which is a first-degree misdemeanor punished by a year in county jail. Do you understand that your current charges are those?
Yes, sir.
I've been handed a plea and sentencing agreement that would have you plead no contest as charged. Count one would be 3 years of drug offender probation with no alcohol, no violent contact with the victim, which means you could have contact, you just can't be violent towards her in any way. An alcohol abuse evaluation and complete any counseling that's recommended or comply with the ECLC or Emerald Coast Life Center. Waive cost of supervision, $870 court costs, $100 cost of prosecution, $100 PD fee, $50 application fee, and then count two would be concurrent 1 year probation. But specifically handwritten in here, I think this afternoon was, you cannot reside in the home of the victim unless the victim requests that in writing, that you be allowed to reside in the home. Do you understand that, Mr. Spivey?
Yes, sir, I do.
Does the victim own the home?
We're all renters.
Yeah, that's what I'm trying to, you're all renters, is that what you said?
Yeah, we all.
Oh, okay.
The lease.
He's lived there for 9 years. He was concerned about his ability to move everything out in 15 minutes, and I informed him this is not saying you can't move it out over a time period. He has already made some arrangements to start moving his belongings when the daughter is not present in the home.
Okay, and it doesn't say he can't go back to the house, he just can't reside there.
Correct.
Is that what you want to do today, Mr. Spivey?
Yes, that's fine, as long as I can get that in writing, that I can go there, because the last time I went there with a police officer, they didn't have it on it that you okayed me a one-day thing to go get my belongings, and I got arrested the last time I was there, even though I was escorted.
So it will be part of your
That's
sentence.
fine, that's
So
fine, as
it-
long as I got some paperwork.
Yep.
To show a police officer, they show up.
You know, could we also add, based on a case we had a few days ago, no threats of violence as well? Besides the no violence?
Part of no violent contact, Mr. Spivey, if I could advise you.
Yes, that's no problem.
Part of no violent contact means no threats of violence as well. You understand you can't threaten.
Oh, yes.
I just want to be clear, but there was 3 separate misdemeanor cases for violation of your release conditions, and it looks like you pled to all of them. So I'll make it clear as possible, but you have to follow that, Mr. Spivey.
What do you have to follow?
You have to follow the rules that say you can't reside there, and if she tells you to leave, you got to leave. I mean, I just read the 3 police reports from the 3 misdemeanor cases where you were found to be there without law enforcement. You just indicated to me that you were arrested even though that you were there with the police.
Yes, that's what I was telling you.
I'm reading that, that's not the case. And it was 3 different times.
It was only 2.
25 mm 1289, 25 mm 1321, 25 mm 1664.
I only had 2.
Would you like me to repeat the numbers again?
I do, but
I just read them all. You pled to every one of them, all 3. Again, I'm not trying to bring that up in a way to upset you, Mr. Spivey, but I'm trying to make sure you understand that some sort of feigned ignorance about what the rules are is not going to be in your best interest. So I'm going to read you the conditions as part of your plea and make sure that you understand them, because I don't want you arrested for something you didn't know was wrong for you to do. Okay? All right. Have you gone over this plea and sentencing agreement with your lawyer?
I have. What she just explained to me as though I only have 2 cases, and one is, right? That's why I have 120 days and 90 days.
Well, you tell me about those 2 cases.
The ones I know of. It's at home with a police officer, and the second time, when they came and picked me up and took me home.
I'm telling you, there's 3 different cases. They may have served you with a warrant on one of them when you were arrested on a different one, so maybe you were only arrested 2 times, but you had 3 different cases from March and April of this year. All right. But back to my question, Mr. Spivey.
Yes, sir. Both of the cases.
Mr. Spivey?
Yes, sir.
All right. Did you go over this plea and sentencing agreement with your lawyer?
I did, but I was only aware of 2 of them.
Okay. I'm talking about misdemeanor cases that appeared in front of Judge Ward that you already pled to. This case has 2 different counts, aggravated battery and resisting an officer. So those are the 2. But there was also 3 separate cases in a different division where you pled guilty to violating your pretrial release conditions from this case.
Don't recall doing that, sir.
You don't recall pleading?
Actually, I don't, because
He's indicated that he recalls pleading to 2 cases. He thought he had 2 misdemeanor cases.
Okay, I don't think it really changes what we're here for today, other than I want to make sure that you're understanding that your previous violations of the pretrial release conditions involved you showing up at the house without law enforcement as was required, because you stated that you only went there 1 time and you had law enforcement with you, which is not what's in the reports.
one time that I did go there with the police officer, and the second time that they came and picked me up and brought me back there. My daughter actually came and picked me up off the street, took me back to her house, stayed there for 8 days. I've got the paperwork right here.
You pled to 2 different cases on April 22nd. That was 1289 and 1321. Then, after those cases were over, you were arrested again in May, and you pled to that case on June 3rd.
What about the April 4th case? Well, where does that fall?
Okay. Mr. Spivey, it doesn't matter for what we're doing here today. I'm trying to make sure you understand that you can't go back to this house unless you're invited.
Okay.
Because if you do that, it's going to be a violation of your probation. You're entering a plea right now to a second-degree felony, which means if you violate your probation, you can get as much as 15 years in state prison. You already, based on this case, score a lowest permissible prison sentence without the downward departure that the state's agreed to, 28.425 months. So if you violate your probation, you're going to have even more points and more months. So I'm not trying to be difficult with you or critical of you about those 3 misdemeanor cases, but I'm trying to make sure you understand how important it is that you don't violate these rules about returning to that house, because otherwise you're looking at going to prison.
My understanding was I can't reside there, I can't stay there. But if her husband, my son-in-law, told me I could come by there and he'd get rid of Nikki for the day and I could get my belongings, excuse me, sir.
I understand that. But I have to make sure that you're complying with those rules.
That's not a problem.
Okay. Again, I'm trying to make sure that you don't violate and end up in prison over something you didn't understand.
I'm going to be leaving anyway, sir.
Okay.
The sooner the better.
Well, you're not going to be residing in that house.
No.
Okay. So, and probation's going to ask you for an address when you talk to them today. So you're going to have to provide them with an address where you're going to be residing.
I get out. Because I haven't been able to speak to anyone, you know.
All right. So now, again, Mr. Spivey, have you gone over this plea and sentencing agreement with your lawyer?
Yes.
Did you understand it?
Yes.
Did you sign it?
Yes.
Are you satisfied with your lawyer's advice and representation?
I am.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir, I'm not.
Are you currently suffering from any mental health issues or concerns?
Not.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for your plea?
No.
If you enter this plea of no contest, do you understand that there won't be a trial of any kind?
Understand.
And then you'd be giving up your trial rights, which are listed on page 2 of the agreement that you signed. Do you understand you're waiving any potential defenses that you may have? And do you understand that if you're not a U.S. citizen, that this could lead to your deportation? And do you understand that this is an adjudication of guilt, which means you'd be a convicted felon on this aggravated battery charge? And you heard the terms that I announced previously. Are those the terms that you understand them to be? All right, so then what is your plea to the aggravated battery and resisting without violence?
No contest, sir.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Count 1, adjudication of guilt, 3 years drug offender probation, no alcohol, no violent contact with the victim of this case, which includes no threats of violence. Alcohol abuse evaluation and complete any recommended treatment. Otherwise, comply with the ECLC program. Waive cost of supervision due to the fact that you're indigent. $870 court costs, $100 cost of prosecution, $100 PD fee, $50 application fee. Count 2 will be concurrent 1-year probation. And again, to address, you cannot reside in the home of the victim unless she requests that in writing to be sent to your probation officer. That she wants to allow you to reside in the home. Otherwise, if you need to remove your things, that has to be done with their permission and under the guidelines that they give you. You can't just show up and start taking stuff out of the house.
I spoke with my son-in-law.
I understand, but if there's a call to the police and you're there by yourself again, which is what happened in these other 3 cases, Mr. Spivey, all of this is for your benefit.
Thank you. I appreciate it.
I want to make sure you understand you can't just show up there and start moving your stuff out without their permission.
Not going there without my son-in-law.
Okay. All right, this is a downward departure based on uncoerced plea bargain with the state. You have to speak with probation before you leave here this afternoon, Mr. Spivey. You also need to be fingerprinted. You have 30 days to appeal the judgment and sentence of the court.
Thank you.
Thank you, Mr. Spivey.
Your Honor, I've made several.
He's the one I'm thinking of,
Yes,
right?
Your Honor.
That he
Yes.
was in the reception center, you missed him, then you try to get him in Franklin?
The sheriff's office had suggested I put a generic language in there and that would work. I put that generic language in there and I thought for sure we'd have them this time. I'm not sure what the issue is, but I'll be following up.
I read the order, obviously, I signed it, and I looked at it again yesterday. The order to transport. Well, maybe, is this the issue? My jail list says he's in Franklin, CI. Your order says Holmes.
Wasn't there also additional language in that one?
Sheriff of Okaloosa County, designated representative, shall travel to Holmes Correctional Institute located in Bonifay, assume temporary custody. I don't see anything about.
Okay.
We just need it with wherever he's at.
She'd given me a phrase to use, so I will see about doing that, Your Honor.
All right. So we'll put him on August 27th. Just get me in order. I kind of feel like you should wait till later, which I'd normally advise against, to make sure he's still at the same place when they get hit with the order.
Your Honor, this is James Strickland, 25 CF 864. Your Honor, the information has been filed on this case. We are waiting for discovery. We are going to need to set depositions, I anticipate, after we've received the discovery.
Where are you at with discovery?
Discovery is en route right now, Your Honor.
August 27th. 9 o'clock.
Your Honor, this is Joseph Eric Thompson. He's before the court on 24 CF 2424. The expert that I mentioned to the court earlier in the day that was going to be used on a different case, I believe it was Mr. Washington, is also the same expert for his case. He was, upon traveling up here to the area, he became ill with COVID and he did not do the visit at the sheriff's office. We are going to be requesting a continuance to the next pretrial conference date.
Without objections.
Do you have a follow-up date for him or her to come see the evidence?
7/29 date, man, gave on the other case?
That's a different expert.
Okay, I wasn't sure.
I don't know of a new date for him yet, Your Honor. I will ask him.
August 27th.
Your Honor, this is Warren Adano, 25 CF 392. We have received discovery. I have been over it with the client, except for any videos. I haven't been over that part yet with him. We have retained an expert. The next part will be to begin depositions. This will involve the state of Mississippi as well. So, Mississippi. Louisiana, sorry, the state of Louisiana. And we are trying to obtain some records from the state of Louisiana as well. So there's several things going, so we're going to need a continuance at this time.
There's no objection.
August 27th.
Your Honor, this is Chayton Trulove before the court on 24 CF 60. Depositions have been completed. In speaking with Mr. Trulove the other day, he had indicated he would like to add some witnesses to his case, and he did not believe that they would be able to travel in time for the July docket. So we are requesting continuance to the September docket, with anticipation of a trial at that time.
Ms. Rivers, have you provided us the names of those witnesses? Okay, I just want to double check with all the filings.
So you're saying he hasn't given you the witnesses' names yet? What's the delay?
I believe he needed to speak with them first, Your Honor.
Not sure I understand that. This case is from January of '24.
Yes, Your Honor.
So I'm not sure how witnesses aren't known 16 months later.
He is facing life as a penalty, Your Honor. These are witnesses that he believes would be helpful in his case.
That haven't been provided to his own lawyer.
No, Your Honor.
Can that be done today? Otherwise, I'm just going to set it for trial.
He's indicated, Your Honor, he can provide me with their names.
I don't have phone numbers.
I guess the issue is going to be contacting them at this point. That he was trying to obtain that information as well.
I understand that, but there's been 16 months to do that. All right. I'm going to put it on June 30th for the defense to supply the state with any potential defense witnesses. If that's not done by the 30th, we're setting it for trial for July.
Okay, Your Honor. Thank you.
Judge, Mr. Trullo's my last case, may I?
Yes, Ms. Basso, thank you.
Your Honor, if I may have a moment to speak with Ms. Ulrich.
Sure. Or to push. It's gotta get this. We have guidelines.
Yes, Your Honor. The VOP is a suspended sentence.
On the new case, it's 6 months county jail on the felony, right?
Yes, Your Honor.
So I think I still need guidelines for that, don't I?
Yes, Your Honor. He is working on a new score sheet, Your Honor.
Do we expect it to be some sort of downward departure, or?
It's been so long, Your Honor, since I looked at that worksheet.
When is the suspended sentence from, do you know?
It's 2000, it would have been her last VOP. May have been 2022. At that time, she signed a two-year suspended sentence. Was it 23? 23. She believes it's 23, Your Honor.
May of 23.
This is a reverse split sentence. But I don't seem to see how it indicates that it was suspended.
So if you read the plea agreements and you read the minutes, it talks about if she completed X, if she completed how much ever time it was.
Auto-term the probation.
If she completed that, then it would automatically terminate and she wouldn't have to do.
That's definitely what it says. I think I would have been a little more clearer on
Yes, Your Honor.
more clear, I guess.
I had not run into that particular phrases before.
Do you have a number at least on the?
The number, yes, it was 49.2.
49.2 points?
Yes, with everything including the original.
So what's that lowest permissible? What's that lowest permissible sentence?
36.9.
I think you including the original.
Oh, sorry. It's 77.
Okay, that makes a little more sense.
Sorry, I was subtracting the 28.
All right, does the state agree that the court's limited to the 2 years on a suspended sentence? Is the state conceding that this is a suspended sentence with a 2-year?
Yes, sir.
Okay. All right. Whoa, hold on. No, the name.
The name, yes, Your Honor, because that was the original.
Silvers is my maiden name.
Okay, so. Are those cases under Silvers then?
Yes, they are. The original cases are under Silvers, yes.
All right. Can you raise your right hand, ma'am? Do you swear or affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Michelle Nicole Ulrich, 8/17/84.
Okay. AKA Silvers, or formerly known as Silvers? Yes. All right. Ms. Silvers, you're here in 25 CF 303, 20 CF 1718, and 20 CF 2285. In the 25-303 case, you're charged with possession of a controlled substance, third-degree felony, and 2 counts of drug paraphernalia. That's a third-degree felony and 2 misdemeanors. Do you understand that? Then you've got the 2 VOPs, 20 CF 2285 and 20 CF 1718, where you have violations of probation with a maximum of, well, I guess 2 years because of the suspended sentence, right?
Yes, sir.
Okay. I've been handed a plea and sentencing agreement that calls for you to enter a admission to your violation of probation in the 2 probation cases, revoke and terminate that probation, impose the 2-year suspended DOC sentence with credit for any time served, $100 cost of prosecution, $100 PD fee, and a $50 application fee. And then in the new case, 25 CF 303, 6 months county jail with credit for time served, $515 court costs, $100 cost of prosecution, and a $100 PD fee. Is that what you want to do here today?
Yes, sir.
Is that the state's agreement?
Oh, I apologize.
State's agreement? State's agreement?
Yes, it is, Your Honor.
All right, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised anything in return for your plea?
Sir.
Has anyone, I'm sorry, do you understand by entering the violation of probation admission that there won't be a hearing on your VOPs and the state won't have to prove that you violated your probation?
Yes, sir.
And do you understand that by entering a no contest plea in the new case, that there won't be a trial of any kind and you give up your trial rights, which are on page 2 of the agreement that you signed? And you understand you're waiving all potential defenses you may have in those cases?
Yes, sir.
And do you understand that by entering this plea, if you're not a U.S. citizen, you could be deported?
Sir.
And in the violations of probation, 20 CF 2285 and 20 CF 1718, are you admitting or denying your violation of probation?
Admitting.
And in the new case, 25 CF 303, possession of controlled substance, and 2 counts possession of drug paraphernalia, what is your plea?
Admittance. No contest. No contest.
All right, I'll accept your no contest plea and your admission to the VOPs as freely, voluntarily, knowingly given. In the VOPs 20 CF 2285 and 20 CF 1718, revoke and terminate your probation. 2 years the DOC sentence that was formerly suspended that will be imposed at this time. Credit for any time served, $100 cost of prosecution, $100 PD fee, $50 application fee, and then in 25 CF 303, 515 court costs, $100 cost of prosecution, $100 PD fee, 6 months county jail, credit for time served. Ms. Rivers, what would we like to do about the financial?
Your Honor, if you could just reduce it to a judgment.
Or outstanding financial will go to a judgment. If I didn't say so, it's adjudication of guilt on all cases, all counts. Need your fingerprints, Ms. Ulrich, and then you have 30 days to appeal.
Your Honor, this is Richard Wagner. He's before the court on 23 CF 2526. He has several other cases. I tried to see him the other day on his cases. I believe it was Friday. I tried to see him, and the pod was locked down due to some incident there. They said I would not be able to see him. So at this point, he and I still need to have a discussion as to whether to set this for trial. So I would ask for a continuance at this time because I do need to speak with him further. Oldest. Your Honor, he's indicated that he's ready to go to trial.
Okay, and this is the 23 CF 2526?
That's correct, Your Honor.
Looks like all of his other pending cases are already set for August 27th. Is there any outstanding discovery in this case?
No, Your Honor.
We shared all discovery in every case, Ms. Rivers?
I'm
just wasn't ready. We haven't done depositions at all, and I know the 23 case.
We've done depositions on the 23 case.
Yeah, before.
Haven't on the other cases yet.
Okay. All right, so Mr. Wagner, that's what you want to do? You want to go to trial on the 23 CF 2526 case, which is 2 counts possession of weapon or ammunition by a convicted felon, a financial responsibility violation, the possession of a firearm by a convicted felon, and possession of drug equipment. Okay, just want to make sure you know, because I know you've got other cases that are pending that are on a different docket. State going to be ready?
Except for checking the availability of the officers, yes.
Okay, well, we'll put it on June 30th for docket day to determine if there's any issues with witnesses. Leave it set for trial.
Have a good day.
All right, thank you, Mr. Wagner.
Your Honor, this is Nicholas Wallace. He's before the court on 25 CF 299, 25 CF 531. We would like to set these for trial.
Both?
Yes, Your Honor. We have deposition set for July 7th.
Eight?
But Your Honor, I have to be clear in this, timing-wise. I'm only available the first week of trial. I'm not here the second week. And we have a few set. Some are older than Mr. Wallace's case.
Mr. Wallace hasn't requested any continuances, Your Honor. Last time we were here, last trial cycle, the state did request a continuance to this time. And that was on, I believe, the 25 CF 299 case.
So if the 299 case didn't go to trial this time around, it looks like it's a speedy trial issue. Showing August 3rd as potentially a 175th day.
That would be fine, Your Honor. We can set it, and then, I mean, other cases may not go as it happens usually.
I'm showing the other case to be September 4th. That would be before the next trial period as well.
I mean, we could try them both together, Your Honor, if he agrees to it.
Let's see what kind of washes out on Monday as far as cases, and I'll point out, Ms. Rivers, you've got 5 of them set now, so. All right.
You want to try them both at the same time, Ms. Rivers? It's the same victim. You know, Your Honor, we could just do them together.
Are you saying yes or no to that?
No,
Okay.
Your Honor.
I thought you said mm-hmm, but then you were shaking your head.
Oh, saying, it is the same alleged victim.
Gotcha. Yes, but no. Okay.
Yes, but no.
So we'll list those both for trial, June 30th for the docket day. And we'll kind of again see where things wash out. As of right now, I believe I've got 15 potential trials. Again, 2 cycles ago, we had 24 after today's date, and had 0 trials. So I'm not too worried about it until we at least get through Monday.
Yes, Your Honor.
And I think we had probably 17 last time and had 1. So I'm not worried about the numbers yet. All right. We'll see you back next Monday, Mr. Wallace, and case will be set for trial.
Your Honor, this is Jason Walterman, 24 CF 1518. Depositions have been done in this matter. I did meet with Mr. Walterman now that he's at the jail. Based on my discussions with him, I felt that an evaluation was appropriate, and I received a letter from Dr. Zeman saying that Mr. Walterman refused his evaluation. I don't believe that I can go forward at this time.
Mr. Walterman, did you not want to see the doctor?
Oh, I saw the doctor, Judge. I had about a 20-minute discussion with him.
Okay. The doctor says that you didn't talk to him about it. I can't hear you, Mr. Walterman.
That would be an untrue statement then.
The doctor's lying.
I'm not going to say he's lying. I'm saying I had a 20-minute conversation with him with a camera on me. So I'm certain that we had a conversation. I told him I did not want to sign the paperwork, that I was completely competent and sane and within my means to have my own say-so.
I think, Ms. Rivers, the place that we're in is, that was an in-house, right? So Mr. Walterman hasn't been ordered.
At this time that I can say that we're ready for trial or go forward in trial based on my conversations with him.
So what are you asking the court to do?
For him to comply with evaluation.
I can't tell, but do y'all have copies? Did Mr. Walterman file something with the
Yes,
court
Your Honor.
himself? Because I can see the memos that go out in response to
Yes,
someone
Your
when they file something from the jail, but I can't see the actual documents that were filed.
Yes, Your Honor, he filed 2 motions.
And what were those?
Motion for bond and I believe a motion to suppress.
All right, so this is what I'm doing, Mr. Walterman. Your lawyer's going to send me an order, and I'm going to order that you meet with the doctor again.
Okay.
And go through the evaluation. The way it's being done is an in-house evaluation, which means no one will see it unless it's in your best interest, and strategically, that's what your lawyer wants you to do.
Yes. I believe that those motions with the statutes and the Supreme Court back-ends, we should probably be able to get this cleared up before the trial date, when I believe it was the 26th of July.
Well, sir, when you file motions by yourself, when you're represented by counsel, they're a nullity, which means they don't count.
But that means,
can I finish?
yes, sir, I'm sorry.
Unless your attorney adopts them. And attorneys won't adopt motions if they don't feel they've got a good faith basis to go forward with them. I mean, I haven't read them, so I don't know what the motion to suppress is about. I know that one of them apparently is a bond hearing. As you know, you're currently had your bond revoked because you failed to appear for docket day when you set your case for trial. So you can certainly bring that to my attention, but I'm not sure why I would grant bond when you didn't show up when you wanted your trial.
I did show up, but it was 2 days later.
Well,
somehow I got that mixed up on my calendar, but I did come to the courthouse and come to checked every door on the second floor here, or third floor, whichever it is.
well, you got to show up on the right day, Mr. Walterman.
Yes, sir, I know that.
All right. So I'm going to continue your case so you can meet with the doctor, go through the entire evaluation with him, and then once that report's done, Ms. Rivers can file with the court if she wants the court to consider it or not. Obviously, if it finds something different, we'll deal with it.
So if she can't move forward, what would that be, to relieve Ms. Rivers of my counsel?
if you feel that she's done something that's ineffective or against your best interests, you can file something that says that.
Absolutely. Okay, thank you.
All right. Otherwise, we're going to set you for August 27th at 9 o'clock. Make sure you meet with Dr. Zeman when he comes out.
Yes, sir.
And discuss what he needs to discuss with you.
Everything he asked me, I answered every question honestly and forwardly.
To be honest, I don't think I've ever heard of Dr. Zeman saying the person refused unless it was an outright refusal. I don't know the circumstance of it, Ms. Rivers. I'm not sure what else the letter said. I'm not trying to pry into it, but I don't see him doing that unless he had concerns he couldn't finish his evaluation with you. I've literally read hundreds of his reports.
I only didn't sign the paper saying that it was okay for them to have the sole say-so for me. Yeah, I was being used in a situation.
I don't know what that means, Mr. Walterman.
Yes, sir. I'll be waiting my doctor's appointment.
Okay. Thank you, Mr. Walterman.
Thank you
We'll
for
see you
your time.
back August 27th.
Yes, sir. Now I go.
Your Honor, this is Jeremy Williams before the court on 25 CF 702. Your Honor, we have set depositions in August on his case.
You asking for?
Your Honor, I'm asking for the August court date, the pretrial conference date. Is it the 27th?
August 27th will be the next pretrial conference. This is the first time up. We'll see you back on that date, Mr. Williams.
Your Honor, this is Robert Lee Williams. He's before the court on 25 CF 550. We've reached agreement in this matter. This is your sheet of paper containing your days, okay?
Do we have a guideline attached? There it is.
Let's go ask you questions.
So the state's dismissing 23 out of the 24 counts?
Yes, Your Honor.
And this is still a downward departure?
A little bit. But yes, it's a downward departure.
A little bit. Mr. Williams, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you step back over to the microphone and you can put your hand down?
Yeah, put your hand down. Just come over here. He's got to be able to hear you.
If you move away from the microphone, it's hard to hear. All right. Can you state your name and date of birth, please?
He wants you to tell him your name.
Oh, Robert Lee Williams.
Can you hear me okay, Mr. Williams?
Yes, I can hear.
All right. I just want to make sure.
Kind of hard at hearing.
Well, then we've got a device we can give you to help you hear better, if you would like that.
I would.
All right. Mr. Williams, we've been doing this since 9 a.m., so I don't feel like yelling at you right now about it. I'd rather just let you listen through the microphone. Can he reach? How's that, Mr. Williams? Can you hear me better now?
Yes, sir.
You can hear me?
Yes, sir.
Okay, make sure you're talking to the microphone. All right, Mr. Williams, you're here in 25 CF 550, where you're charged with 23 counts of burglary of an unoccupied conveyance and 1 count of burglary of an unoccupied structure. Those are all third-degree felonies punished by up to 5 years in state prison. Do you understand that?
Yes, sir.
All right. I've been given a plea in the sentencing agreement that calls for you to plead to count 24, which is the burglary of an unoccupied structure, for 11 months, 29 days in the county jail, credit for time served, $415 court costs, $100 cost of prosecution, $100 PD fee, and a $50 application fee. And in return for that plea, the state's going to dismiss the other 23 counts of your case. Do you understand that?
Yes, sir.
Is that what you want to do here today?
Yes, sir.
Is that the state's agreement?
Yes, Your Honor.
And he scores about 14 months, is from what I've seen, so it's a little bit of a downward departure.
Yes, Your Honor.
All right, and that's based on uncoerced plea bargain?
It is, Your Honor.
All right, Mr. Williams, did you go over this plea and sentencing agreement with your lawyer? Did you go over this agreement with your lawyer?
Yes, sir.
Okay, and did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you under the influence of any substances?
No, sir, I'm not.
All right. Are you currently suffering from any mental health issues?
No, sir.
No?
Yes, a little bit louder. In here. You gotta say it louder. Say no, no, sir, in here.
Okay, repeat that question, Your Honor.
Are you suffering from any mental health issues right now?
Oh, no, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
Sir, no, sir.
Has anyone promised you anything in return for this plea?
No, sir.
Do you understand by entering a plea there won't be a trial? Do you understand there won't be a trial if you enter this plea?
Yes, sir.
Okay, and do you understand that you're giving up your trial rights, which are on page 2 of the agreement you signed? Yes. I just need you to say it out loud, Mr. Williams.
Yes, sir.
All right, and do you understand that you're waiving any potential defenses that you have? You're giving up any defenses?
I don't understand the question. I don't understand the question.
You're giving. Oh, you give.
Mr. Williams, do you understand there won't be, if you enter this plea, there won't be a day that you come back to court and say, I didn't do this?
No, I'm happy with the agreement that on this 11/29.
Okay, so, but you know that there won't be a further trial of any
Yes,
kind?
I understand that.
All right, and do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea to count 24, burglary of an unoccupied structure?
No contest. You gotta tell them no contest.
No contest, Your Honor.
All right, no contest is indicated on your form as well. I'm going to accept your no contest plea as freely, voluntarily, and knowingly given. State have an announcement on counts 1 through 23.
The state will null cross them, Your Honor.
Okay, does the state want to put anything on the record as to why this agreement was made?
Nothing on the record, Your Honor.
Okay. All right, so on count 24, I'm going to sentence you to 11 months and 29 days in the county jail, credit for time served, $415 in court costs, $100 cost of prosecution, $100 PD fee, $50 application fee. You're adjudicated guilty as to that offense. Time to pay or just judgment?
Judgment, please, Your Honor.
All right. Your monetary obligations will be sent to judgment, Mr. Williams. You're going to have to take care of that when you get out.
Thank you, Your Honor.
All right. All right. I need you to be fingerprinted up here, Mr. Williams, and you have 30 days to appeal.
Thank you, Your Honor.
Here's your sheet, okay?
Charles Russell, Public Defender's Office. Judge, this is Wanda Carpenter. Case numbers are 24 CF 909, 24 CF 1124. We are waiting for a second competency evaluation from Dr. Zeman. He's scheduled to see her within the next week. The state's going to provide me with new addresses for some of the witnesses on 1124. This time we're asking for a continuance to the next pretrial conference date. If we get that second competency evaluation, we of course can schedule it sooner.
State?
State has no objection to that. Additionally, based off of the courts and the defense's request for 24 CF 909, we looked into it, and the state is going to null pros that case based on insufficient evidence to prove beyond a reasonable doubt. That's the one where the victim is deceased, Your Honor.
Okay, so 909 is dismissed. We just have the 24 CF 1124 left. What date did you ask for? The 27th of August?
We'd like to set it for the 27th pretrial conference. If we get Dr. Zeman's evaluation before then, we'll of course bring it in sooner.
Of course, we'll bring it in sooner once you get that evaluation. Ms. Carpenter?
Yes, sir. I have a question. I'm unaware, I just was informed that you're not aware of this.
I don't know what that is.
It is a victim's rights voucher.
Okay, brochure?
May I hand it to you?
No, ma'am. You'd have to show it to the state attorney first. Has your lawyer seen what it is?
I have. I gave it to him. He said he'd make copies and let you know, and I guess you're not aware
Well,
of it.
they don't just hand me information about the case.
He said, he just told me right now you didn't know about it, and that's why I gave it to him the last time we went to court.
I believe the paperwork she's referring to, Judge, is what she showed me one time in a jail visit. It's where she has filed a complaint against the alleged victim in 1124, Mr.
James Villarreal.
Mr. Villarreal. And, okay.
Is there a case pending from that?
She says that there's an investigation. I do not know. I have not been able to independently confirm any of that.
The deputy's name is Officer Dacey.
So what that means is you made a report, but there doesn't seem to be any confirmation that law enforcement submitted any charges.
I haven't heard anything. Is there any way that, when am I supposed to hear anything?
I don't know. I mean, you can certainly try to reach out to the
I
deputy.
tried that.
Ms. Carpenter, you can reach out to the deputy, but contrary to popular belief, I don't have access to the sheriff's office's entire database. I just don't know what's going on with it. So you'd have to contact them to find out if they're pursuing that charge or not.
This is the whole reason why I'm in here. On false allegations on the disposition he did.
Well, your lawyer says that he hasn't been able to confirm that there's any charges because of that.
That is because he is running down south. I was in jail with his baby's mom, and he ran down south because he's guilty. He ran. No.
I'll let them look into it, but I'm not an investigator. That's not
understand.
what I do. So if there's something to be found, someone needs to contact the sheriff's office about it.
I haven't turned in state evidence. The pants I was wearing that night.
I understand.
Yeah.
Mr. Russell, have you been able to contact them?
Mr. Villarreal, Judge, is the alleged victim in 1124 that the state's trying to find. He's the one that we sent a subpoena to Walton County Sheriff's Department. They returned it as not at that address. So the state's looking for him and then for two of the police officers they've listed. So hopefully that we'll know something. The court gave him a deadline of July the 9th to find those people. So that's what we're waiting on right now.
Disposition since August 25th last year.
I had depositions. I had depositions scheduled, and that's when we got the return from the sheriff's department saying he's not at that address.
And And as a victim, I'm supposed to be not tried in a jail setting where other people are threatening or physical or mental abuse or even the COs. But since I stepped forward with that, I have nothing but peer harassment in that jail.
Ma'am, I don't see any pending cases for him, and the extent that I can see it, I don't see a warrant for him. So you're going to have to contact the sheriff's office and find out if they're pursuing that investigation or not. All right, but your next court date's going to be August 27th. As soon as that report comes back in, we'll get you on an earlier date.
So if it comes back, if y'all don't hear from him by the disposition date that's set with that, then if I get the competency evaluation, it says I'm competent, what, do I have to stay here until?
You're going to have to talk to your lawyer about that. There's a lot of contingencies in what you're asking.
Yeah, I
so I don't want to sound like I'm telling you what's going to happen until I know all the facts myself.
You're good.
Okay. You have to understand, Ms. Carpenter, I don't look out trying to find things. They have to bring it to me, and I make the decision based on what's presented by each side. So I'm just not allowed to do what you're seemingly asking me to do. But I'll certainly consider everything that's provided to me. All right. Thank you, Ms. Carpenter.
August 27th right now. Judge, this is Joseph Carroll. Case number is 24 CF 2383. Two things. We're asking for continuance to the next pretrial conference date of August 27th. Mr. Carroll filed a petition for Nelson hearing. We've set that for July the 10th at 2.
July 10th, 2 o'clock for the Nelson hearing. Let's just put it on that date, Mr. Carroll, and we'll see you back on July 10th, and we'll set your new court date from there. Well, actually, I'm going to set it for the August 27th date, just in case y'all resolve the Nelson issue, which often happens. That way you have a court date still. All right, thank you.
Judge, this is Jonathan Collins. Case number on the docket is 24 CF 2510. In prepping for today's court, I found out that Mr. Collins has a new case, 25 CF 1041, that is pending in the South End. I anticipate that the state will be transferring that brand-new case up here, and so we'll have both of them. So at this time, I'm going to ask for a continuance of the 24 CF 2510 to August 27th, and then by that time, we'll have both cases, or should have both cases up here.
Okay, you understand that, Mr. Collins?
Sir.
All right.
State's fine with that, Your Honor.
August 27th, and just make sure if the state does the paperwork in order to transfer up the 1041 case. All right, thank you, Mr. Collins.
Judge, this is Kip Fee. Case number for the record is 25 CF 691. On Mr. Fee's case, we just got a competency evaluation from the doc the other day. So we're going to ask that he set it for a competency hearing on July the 10th at 2 o'clock. We filed and provided copies to the state.
With all due respect, I was going to go ahead and ask for probation if that was okay because my mental health was getting severe. I've been on probation before.
You have the evaluation, Mr.?
I can show you, Judge.
I mean, I don't necessarily need to read the whole thing, but
Just because I've been dealing with bullying is the only reason I ask. And I've never missed a court date on the outside.
I understand that's not quite the issue, Mr. Fee. The issue is we have to have a competency hearing, which will take place on July 10th.
Okay.
To determine whether or not you're competent to proceed. That's not just a trial, that's to make the decision if you're going to plea, so I can't just let you
I can go ahead and plead today.
Mr. Fee,
Yes,
I
sir.
have to make sure that you're competent to even enter a plea.
I believe that I am.
Well, the doctor seems to differ with you, so we're going to have a hearing about it on July 10th.
Okay.
All
Do you
right,
know if I'll
thank-
get out then?
I don't know. We'll have to
Okay.
have that hearing
Sorry
first.
about that.
All right, thank you, Mr. Fee.
Thank you.
Ms. Barrettman, there's been a change in the offer. I relayed that to Mr. Keaton. That's going to stay open through Monday, and he's going to talk with his family about it.
So we'll keep them on for June 30th as what, plea or continue?
Yes, sir.
All right, Mr. Keaton, we'll see you back on Monday.
Okay.
To talk about that new offer and whether or not you want to take it. All right, thank you.
Doctor, sorry, I'm looking at where it says docket day and just, Judge, Juris Doctor.
First, because I said you should
I've
go
been called a
first
lot of
before
different
me.
things today. I wonder what some of them are in the back.
I would be very happy for that to happen. So Judge, what I'd like to do is leave this on for docket day, plea or continuance. I've got an email out trying to, I'm trying to get the case resolved. We might be able to get it resolved that early. Otherwise, I'm going to have to continue it and get some records unsealed.
Case is pretty old.
Yes, sir. That's one reason why I'm trying to get it resolved.
All right, plea continue?
Yes, sir.
All right, June 30th for plea or continue.
Thank you, Judge.
I'd like to hear more about what the holdup is if it's not a plea on Monday. Oh, talk to your lawyer about it.
Okay.
Okay.
Thank you.
All right, thank you. Judge, I'm going to move to continue this case.
Hey,
There's no objection.
is this the first time up? Looks like it.
May not
Might
be.
be two.
Yeah, maybe two.
It's not particularly old, Judge.
You understand, we continue to August 27th, Mr. Bradshaw?
Yes, sir.
Actually, Judge, I've got my investigator looking on at something. I don't want to announce ready for trial yet, but I should have an answer on it by Monday, and that might change things.
So you want to put it on Monday?
Yeah, if we can put it on Monday, Judge, I'd appreciate it.
All right, we'll see you next Monday, Mr. Bradshaw. Plea or continue?
Yes,
Okay.
sir.
All right, we'll see you on Monday.
Thank you.
Thank you.
Judge, I think we're going to be able to get this one resolved. I've got it as pass. I've got it as pass for docket day for plea or trial. Let me look at this real quick, Judge, make sure that's not, oh, I know why. It's a year old. It's one of Tim's cases. So we need to get it resolved.
All right, so we're putting it for plea trial on Monday?
Yes, sir.
Mr. Braley, we'll see you back on Monday, June 30th for plea or trial.
Yes, sir.
Thank you.
Mr. Williams,
Yeah.
I think we can discuss this. Somehow, what I'm saying, Your Honor, is charged mistakenly with a second-degree felony. For some reason, the system.
Mr. Braley, are we talking about?
Yeah, Braley.
Okay, I didn't know if you walked out yet. I
Oh,
wanted to
yeah,
make sure
yeah.
you were here for
He told
this.
me about that, and I passed that along to him. Actually, what I'm going to try to work out with you is Dana's got him in the dorm, and he's doing really good. So I'm going to be looking for some kind of alternative.
And I'll be fine with that.
Well,
So-
let's leave it on for Monday then.
Plea or continue, because
Okay, we can do it that
we can
way.
resolve it. Yeah.
As long as it's not me.
As long as it's not what? What's that?
Oh, the
We're going to
continuance,
do a
you
plea or
mean?
continuance instead of plea or trial. So as long as it's not me getting.
I just think we
judged
can
upset.
resolve it, Your Honor,
It
with,
sounds like there's a potential resolution between.
There is.
What was said in ECLC and.
Yes, sir.
Yes.
All right, I'm fine with that.
Judge Charles Russell, Public Defender's Office. This is Caitlin Bramble. Case number for the record is 25 CF 159. On Ms. Bramble's case, Judge, we've got a competency evaluation, so we'd like to set it for a competency hearing July 10th at 2. And this will be Mr. Maddox's case.
Got it listed as Williams. You're doing it. It's going to be Maddox.
Sorry, Judge. We're moving around a little bit.
It's a shell game. See if you can find a.
All right, so we'll see y'all back on July 10th at 2 o'clock for the competency hearing. And then pretrial will be August 27th.
Thank you, Judge.
All right, thank you, Ms. Bramble. We'll see you back.
See you, okay.
Judge, I think we're getting close to a resolution on this. I'm got my investigator checking on something. I'm hoping he can have an answer for me by Monday. If you want to leave it on for Monday, plea or continuance.
Well, this, Your Honor, I would like to set it for trial, plea or trial.
Depots have already been
Right.
done, so I'd say that's probably okay.
Brown, are you wanting to plea your trial for Monday?
Yes, sir.
Okay. I just know we were here on a Nelson recently, and I know you want to get things done. So we'll put it down for a plea or trial. We'll come back Monday and discuss it some more.
Thank you very much.
All right.
Ms. Casper.
Judge, this is Ms. Castor. She failed to appear at previous docket day, and the court revoked her bond. I'm going to have to schedule a bond hearing. She's advising me she's got some severe medical issues, but we'll deal with that at the hearing. For right now, I'm going to ask that the case be continued, though.
Your Honor, state is ready for trial. It's an older case, and it's a very straightforward case. She was given a chance, then she failed to appear. Additionally, I have information that she got involved with other people involved in criminal activities, so I'm very concerned about the safety of the community, about this lady getting out, and I would like to set it for trial.
Judge, what she's advising me, do you mind if I tell him what you're, is that she's having kidney stones, she's unable to pass them, she's in such severe pain. I'm concerned that she would not be able to adequately participate in a trial at this time, not without some medical treatment, or at least MD's opinion that that she can. Unfortunately, it's more of a medical decision than a psychological decision.
Yes, they do. They have them up at, they have them at the jail.
She's in.
I had a stent. I'm in kidney failure, and I've been in white for 14 days, and they won't give me no medicine or anything. I'm in so much pain. I can't do my time like this. I have no problem doing time, but I cannot do it like this.
So what I'm seeing is she didn't make court on May 5th
I was
because
in-
ma'am, if I could
sorry.
finish, because she was in jail for a new theft. So it's really not a failure to appear as much as a now revoked bond because of a new law violation committed while on bond. appears that she's already pled to that case. And she was given 30 days. She should have been by now. I'll continue the case. If you want to get a bond hearing, you can certainly schedule one. But it'll be last continuance short of some documented medical issues.
Yes, sir. Yeah, I'll have to schedule one for you. Judge, Mr. Firestone was actually Mr. Maddox's case. Yeah, he's... It was originally Tim Gibbs' case. He was arraigned, then failed to appear, and was put back on the docket. And when I pulled it up in stack, I showed it as...
Judge, I don't know anything about it, so June 30th, Monday, Mr. Maddox will be back.
I've got to
address it.
Sure.
Okay. The state offered 2 years of probation. Okay. I have one request. My license is suspended for 5 years no matter what. So if I take this third DUI and get on probation, it's going to be 10 years. I want to do the probation, and I'm asking, even though I'm a felon, I would like to get if it's completed now, adjudication withheld.
Can't do that on a DUI.
Okay, can I sign the 2 years probation today?
Is that the offer?
That was the offer.
Yeah, it's 2 years probation.
Early
plus-
termination?
Sir?
No.
Can you let him?
Yes, sir, I apologize.
Yep. For the possession, it would be 2 years probation, substance abuse evaluation and treatment, and then it'd be all the standard DUI, but it's a third within 10. I don't have those memorized at this time, Your Honor. I'd look up from the offer that we sent.
How long have you been in jail?
7 months, sir.
Okay. Making sure it was a 30-day minimum on a third within 10.
Of course, yes, sir.
I just wanted to make sure it wasn't something different. Have you met with a lawyer?
Yes, sir. I know it.
Hold on.
I apologize. Go ahead.
You're trying to think in advance of what every question is going to be. Just wait and listen. Who have you met with? Okay, so you're really Mr. Maddox's case, and for some reason it's listed as Mr. Williams, but he doesn't know anything about your case, and Mr. Russell, who's also here, doesn't know anything about your case. I mean, I don't mind bringing you back on Monday, but so your actual assigned lawyer is here who knows about your case and has talked to you about it. But I don't really like the idea of them not knowing anything about your case, having you plea out to something that maybe is not in your best interest.
The state has already said they will not do the 9 months run concurrent with all credit for time served. My father just died in here, and my mom's by herself, so I hate to say it, it almost feels like this might be, and if I'm going to get out and do right, I shouldn't have any problem with this, if that makes any sense.
I'm not sure what you mean. I'm not sure what you mean.
I mean, if I'm willing to go out there and do what's right, this shouldn't be a big deal for me.
Well, I understand that. It's just making sure that's what you actually want to do.
Yes, that Mr. Firestone could waive counsel.
Well, then I got a lot of other things to go through.
The next docket day would be this coming Monday?
This coming Monday. 6 days. I don't have any dockets between now and then.
Okay, that's fine.
I'm just telling you. I mean,
I appreciate your honesty. Then I'll wait until, if it's just Monday, I see no reason why I can't wait.
And then if Mr. Williams or Mr. Russell, if you could pass on to Mr. Maddox that he seems to want to enter a plea, and if Mr. Maddox would go talk to him about it, that way you guys are ready on Monday and there's no questions.
I'll let Mr. Maddox know.
Okay, we'll see you on Monday, June 30th. But just so you know, Mr. Firestone, in DUIs, there's a lot of mandatory penalties and things that can't be waived, including adjudication can't be withheld. It's not a question of discretion, it's just not allowed. All right, thank you.
Judge, this is Mr. Gary. Case number, we've got two cases, 2023 CF 2006 and 2023 CF 2366. He was returned from Florida State Hospital. I asked Dr. Zeman to take a look at things, see if there's an NGRI. Have had conversations with him, and I'm expecting a report, but I don't have it yet. So I'm going to move to continue the case. I don't think he's been back that long. I think this is maybe his first or second time since coming back. I'm trying to recall if, what I'm remembering as the first was actually his competency hearing.
I think he came back on May 1st, was our first court date. On August 27th at 9 o'clock, but if you get that evaluation back, Mr. Williams certainly set it on an earlier docket if we can address it and move things along. All right, we'll see you.
Thank you very much.
Thank you, Mr. Gary.
Judge, this is Jarlib Hagens, 2023 CF 2295, 2024 CF 2607. Judge, if you'll recall, this is the individual trying to work out all of his cases. He has a new law violation, or he's got a couple of cases over in Santa Rosa, plus he's got a warrant out of there. Santa Rosa apparently just did him as a failure to appear and issued a capias for him. And what we need is to have him transported over there so he can get the warrant served so that they can then begin working on that case and we can try to coordinate something that involves everything. But our office over there just has him in failure to appear status, so they're not really doing anything until that warrant gets served. I sent an email over to the court and to the state asking if anybody had an objection to me doing a motion in order for you to order him transported to Santa Rosa and then returned. And it's purely to get the warrant served on him and get things started over there again. My practice from prosecuting over there is that they won't serve him anywhere else. They want him there in Santa Rosa and to do his first appearance there in Santa Rosa, unless things have changed with the new admin.
Then they will keep him in Santa Rosa.
We do a motion in order to bring him back over here.
We lose him.
We don't lose him for long. I just do in fact, we can put in the original motion in order, transport him and then bring him back on such and such a date.
And you don't, I don't know because I haven't participated in communicating with the Santa Rosa people. It's a brand new case.
Yeah, it's a warrant. And
probably the prosecutor hasn't even looked at the PC.
Probably not. It's a trafficking charge, I believe.
Oh.
So, it's not.
So it's not something that can be resolved by emails altogether.
I don't know. I don't know if they got labs back on it. If they got labs back on it and it turns out negative, then sure. But otherwise,
I'll leave it up to the court. Whatever. I'm fine to continue the case for this purpose, but to transport, whatever, it's the court decision.
I'm kind of volunteering to do more than what would ordinarily be my job to do, but I'm just trying to get this.
I just don't want to be in a situation where he goes over there and has to work on that stuff for months and months. Or if we send him over there and then have him return, well, then what are they going to do with their case now that he's not there anymore?
I'm envisioning, as painful as it is to say, that he's going to have to go back and forth on these court dates.
I don't, unless he's going to pay for that transportation every time. I'm not sure that's what we can do. I'm not going to basically order that two different sheriff's offices, transport him back and forth between two jails every month or two.
Yes, sir. If I can answer a question for him.
Is there a plea offer on this, Ms. Leone? I mean, he's been in jail since November here. There's a possession by a convicted felon, but I don't know if that's a mandatory or.
Yeah, that's the 2023 case, so,
24 is drug possession.
yeah.
I've got, in my notes from last time, I've got new offer on the table, guidelines without mandatory minimum or 36 months mandatory minimum, defendant's choice. And
Guidelines.
his PD in Santa Rosa had, on the cases that he already had over there, had an offer for 36 months with restitution. And that the issue really is just the pending warrant. So it looks like everybody's kind of in agreement on 36 months without regard to the pending warrant.
I mean, except there's a trafficking case out there, which
Right.
is at
And
least another potential 3-year minimum, if not more, depending on what it is and how much it is.
Well, and obviously, what I think Mr. Hagan's hope would be is that case could be negotiated down off of trafficking, or if it was trafficking, it'd be the low end where everything could be done and run concurrent.
Yeah, my only thing, Mr. Williams, is that with this level 5 felony, which is the current one, he scores minimum presumptive 48 months DOC. So I'm thinking that if he's charged with any trafficking case that it's a level 7, that's just going to go higher instead of going lower. My offer was a downward departure, basically for the sake of a plea.
Yes, ma'am.
I'm willing to do the 36 months without min-man. So he goes to handle, that's, with my case, that's all I think I can do.
Right, we understand that you can't negotiate the Santa Rosa case, certainly not the one that hadn't been served on him and you don't know anything about. Just like I can't represent him in a trial on that. So, again, I don't mind drafting up the thing, or we can pass him until Monday and go out and talk with him again, but my,
I'm not inclined to transport him back and forth, county to county, on every single court date.
all right, his next question is this, and Judge, let's do this. Let's pass it until Monday, and so that you and I
I
can
know
talk.
his question and what it is. I think
Yeah.
they're going to let him do the Santa Rosa and then send him.
That's
to
what I
DOC.
would expect. That's what would make sense, but
If they'll let me, I don't want to go to prison without going to Santa Rosa first. If I can get sent to Santa Rosa first, I'll sign the deal over here today. If it's a guarantee that I'm not going.
Well, if he's got a KPS from Santa Rosa, they're going to send him there, aren't they?
No, yeah. What I was trying to say, in another case that we have, the defendant was sentenced in Walton County to DOC, right? And I have now his pending case, so he did not get sent to DOC. He's here now to handle our case before he gets sent to DOC.
well, and here's the thing. If that
Was
were to happen.
was it a pending case or was it a warrant case?
A pending case.
I think that might be the difference.
The difference,
So
you think?
I think the good thing is he's got the pending case with the KPS. They'll probably pull him over there because that's an active case. If it were just a warrant case, I think they send him to DOC and say, we'll deal with the warrant once he's done with his.
That's what I'm not trying to have happen. I want to be able
No,
to just
I
take
know.
everything, and I don't got no discrepancy on signing no plea agreement right now. I don't got no discrepancy with that. I'm not trying to go to prison and get out of prison and come right back to fight a whole nother case. That's what I'm not trying to do.
We'll do this. Set him for Monday. Figure it on your end, Mr. Williams. I'll reach out to Judge Drake, who's going to be your judge in Santa Rosa County, and see if he has any concerns. But of me just doing an order transporting him over there or him,
Yes, sir.
or Judge Drake doing in order to transport him over there, so we know that happens before you head to DOC, if that's what it's gonna be.
The whole problem is y'all think I'm going over this shit like I'm planning on asking for a speedy trial off the dribble. When
Well, I understand, speedy trial is still 175 days.
I understand, but I ain't just looking to go sit over there for, you know what I mean, for a whole another year or anything like that.
You know, I think what we're trying to do is accommodate the idea of you pleading here, but being certain that you're going to go to Santa Rosa to resolve that case before you get transported to DOC. And that's, I think, what we're all kind of on board with doing, but it's going to take us probably until Monday to get that figured out.
And I don't really get into it, but there's this idea that if you get a bunch of different minimum mandatories in different cases in different counties, they automatically all run together. That's not how it's supposed to work. That, you know, these can all be consecutive time. I'm not trying to be, you know, sound like I'm threatening here, but I'm just saying, these things need to be worked out. And I'm not, Mr. It's Hagens, right? Okay, I just froze on your name for a second. Mr. Hagens, I'm not saying I'm going to do anything different, but if we can resolve our cases and then send you over there, and then you can resolve the cases that are over there, okay, but we can't keep going back and forth about how all these are going to run concurrently and to your best benefit, but you've got to make some decisions. I mean, I'm not trying to be, you know, draconian here, but I could just say it's time for trial and we'll see what happens. Or you can plea, take the state's offer, you can plead straight up, but you have to resolve one county before the other. You know, it's not like there's a bus that goes between the jails every day.
I understand it. That's what I'm saying. If you saying that Santa Rosa's will come get me to go over there before I go to prison, I'll sign right now.
Okay.
But if
I can't guarantee that. They're going to look into it on their side. I already told you, I will personally call the judge who's going to handle your case, who I've known since we were baby lawyers. And I sat on the bench in Santa Rosa County before I moved over here 2 years ago. I'll give him a call. We talk all the time and say, hey, this is what we plan on doing on this particular case of yours. Do you mind doing an order transporting him over there to make sure he gets there and can resolve both his pending case and his new warrant before he ends up getting off to DOC, and those cases are never going to get resolved until you get back from DOC. I like to resolve cases like that. There was a bill in the legislature this year that would have allowed it to be easier to bring people back from DOC to handle their cases, their warrants, while they're sitting in DOC, and it didn't go anywhere. So I'd like to get it done, but we've got to make some phone calls.
Judge, let's set it for docket day. If you think that'll be enough time.
Yeah, I mean, I'll give the call.
And I'll come out and explain it to you, but basically, he's trying to do what you're needing to have happen. There's just no guarantees, okay? All right.
Just so you know, Mr. Hagens, I'm writing a Post-it note I'm going to stick in my pocket so I remember to call your judge. Who do we have?
This is Alicia Havens. I do not have a case number on her. She was on yesterday's docket, but she had not bonded out. This is the lady court gave her an ROR bond, but she's got a VOP in another state, didn't want to, either another state or another county, didn't want to risk getting a failure to appear over here. So, Judge, what I've got.
Oh, your first name again, Ms. Havens.
ALESIA.
You got the case number?
Yes, Your Honor, 25 CF 44.
Judge, what I've got on here is I just announced ready for trial on it. We've sent over letters from the alleged victim. The state also has, on their own, gotten a letter from they provided in the discovery. No, excuse me, I'm confusing that with another case. This one, you've not had any contact, at least the last time we were in court, I think. So let's just go ahead and set it, and either they'll be able to get a hold of her or they won't.
Done it for trial. Another thing, I can see that Ms. Havens may have sent some sort of correspondence into the clerk's office. I can see their response memo to it, but I can't see the correspondence.
Judge, I might be able to help you with that. Sometimes we get those. Well, sometimes we get those and they actually wind up in stack.
Can I speak about?
Go ahead, ma'am, but if your lawyer tells you to stop, please do.
She had gone down to drop the charges.
Who's she?
Madison McPherson, she went and dropped the charges, and he has a notarized copy of where they dropped the charges, supposedly. And
Well,
I've been here
you
2.5
have to
months.
understand, ma'am, that the state makes the decision to drop
And she
charges or
also
not.
moved out of state. She lives somewhere else, not even in Florida
All
anymore.
right, so it sounds like a trial. And the state can try to find her as a witness or not. State? You had any contact with the alleged victim?
Not recently, Your Honor. So we're going to be doing a subpoena just to make sure that we get it and the state is prepared, Your Honor. But we do not and have never gotten a drop charge that I'm aware of in this case, Your Honor.
Judge, I'm looking through what I have, and like I said, I think that other one was from another case.
Let's focus on this one.
I'm looking through it, okay, right now. You can help me look through it. That's state discovery. No, this is an affidavit of complaint. Judge, I've got.
You had the paperwork the last time.
Just a second. Go ahead, Mr. Williams.
I'm sorry, it was attached to the bond motion that we filed back in May. At least that's what my bond motion says.
Would like to drop charges against Ms. Havens was a misunderstanding.
Yeah.
Yes.
The case that I was thinking of has a longer statement, and then they also went down to the
All right,
state
let's-
attorney's
again,
office.
Let's focus on this one.
It was about a camera.
Just looks like on the attachment to the bond motion, initially has her MM case number. Above that, it's got the CF number.
Yeah, all this has been going on since around November for me.
Well, I understand, ma'am, but has the state seen this particular?
I'm looking at it right now, Your Honor.
I mean, it's a sentence, so.
It was like a $20, less than $20 camera.
We'll give the call. Hopefully, this is a good contact number.
Date and change.
Ma'am, you got to let other people talk.
State is fine with plea or trial, and we'll knock this out. See if we can get it dismissed
All right, plea your trial we'll see you back on Monday.
Thank you, Judge. Judge, case has been around for a while. We did get some further information, but we haven't provided any reciprocal on it because it came in, I think I saw it this weekend. My investigator heard from one of the officers up in Tennessee with more information, and then we wound up talking with Robert Hitch, the owner of the Forerunner. Let's set it for Monday. I don't know whether to set it plea or trial, though, or plea or continue, but at least then we can get that information over to the state and make a decision on it.
It is ready for trial, Your Honor. And I have a sense of what he wants to share with me. I don't think it's relevant, so affect my case.
It looks like we did file reciprocal on it, but it was filed yesterday.
Have you received that, Ms. Lee?
Yes, I believe it. I can tell you, Your Honor, I received the police
Reciprocal
report
discovery.
from another state, and he shared the
I
name
will
of his
tell
own
you later.
investigator. That's all I have. So if he needs, again, if he plans on using that, I will file a motion in limine to object to that evidence, so.
Well, we'll just have to fight it out at that point.
Okay. So do you want to set it for trial?
I don't know because I don't know that we can get this fella in. I'm going to have to talk with him personally, I think, to see if he'll come in voluntarily. He's in another state, so, and we don't have time to do the judicial process of going to that other state. It might make, it might be.
Down for trial or continue, depending on what you tell me on Monday. But unless there's some sort of definitive plan about what you're going to do and you're going to have this guy testify, okay. But I don't want to keep pushing off this case. I mean, we had a
Yes, sir.
suppression motion like 6 months ago, wasn't it?
Yes, sir.
And just.
I'm going to leave the offer open, Mr. Williams, to one trafficking charge instead of two, but if we go to trial, I'll have both trafficking.
I feel like I have to ask this question. Do you have an FDLE report on both items?
I believe I do. Yes, Your Honor.
I've seen FDLE reports.
Okay, I just want to make sure.
Yeah.
Had situations where things weren't what we thought they were, right?
Yeah, but I do know, Your Honor, that when it comes to trafficking cases and case set for trial, they would prioritize the case that is set for trial. So I will have it.
I've
by
heard
then.
that.
But I will have it. I would have it. So.
But has it been turned over or not? That's going to be the issue too. I mean, if it's the one big piece of evidence, I mean, it's one thing if it confirms it is exactly what they thought, but.
Yeah, if it doesn't confirm it, it's non-controlled substance, and we go without that, you know. But one, we do have it, and it's confirmed. Yeah.
Okay.
Yeah.
All right.
Judge, I'm looking at it right now.
I'm going to write it down as trial or continuance based on, you're going to have to tell me why you need the continuance still on Monday, Mr. Williams.
Yes, sir.
By talking to whoever you need to talk to. This case is 14 months old, almost 15 months old.
All right, Judge.
All right, Mr. Horn, we'll see you back Monday.
Reciprocal is our evidence that we're going to use, okay? Means, okay? All righty.
All right, we'll see you Monday.
and not the greatest time to do it. I'm sorry, what's your name, sir?
Matthews.
Yeah, okay.
Rowan Matthews.
Is mine.
Judge, can we do this? He's asking me a question I want to try to answer here at the bench. Can we pass him until Monday for plea or continuance?
This is the first time up, so.
Yeah, that's fine, you're on.
All right, plea or continue for Monday, the 30th.
All right, so what I'm going to do is I'm going to come back out to the jail, ask me then, okay? This is not the time or place. Judge, this is the key. Moore spoke to him out at the jail yesterday. I sent an email over to Mr. Sick with a counteroffer that he had made. Can we set Mr. Moore for Monday for plea or continuance? The case looks older, but what happened is he failed to appear at his first pretrial conference after arraignment. So there was a period of time that he was at large. He's just been rearrested. In fact, I think we just reopened the file.
All right. Any objection to plea continuance for Monday?
No objection, Your Honor.
All right. Mr. Moore, we'll see you back on Monday for plea or continuance.
And Mr. Sick, the counteroffer's like 180. Yeah. County jail. You'll just take a look at it. Okay. Something here. Yeah, still not bad. All right. You're. No problem. Judge, this is Mr. Norris. Hang on a second, I'll announce the case number.
I haven't memorized mine now.
21 CF
2144.
All right. Judge, I've talked with the state about it. I've talked with my client. Don't want to go into too much detail right now, but it looks like we're going to go ahead and go to trial this time. State advised me in a conversation that I had with them that they had done a motion in limine. I haven't seen that yet and did not find it when I looked in stack. It may be a situation where with the new computer stuff, it hadn't made it over to me yet. But we'll, I'm sure, get.
If that's the case, Your Honor, I'll make sure and pass on to Ms. Sandler to give that to you, direct it via email.
A lot of it we may be in agreement with.
Can we get that? Would you like that as well, Your Honor?
I mean, we'll end up talking about it on Monday, but if it's just mostly boilerplate type stuff, then it's not a big deal. But they can send a copy over to me.
Okay. All right, Judge.
All right, and just for the record, we continued it previously last time due to a possibility of y'all filing a
writ.
Writ of prohibition. Has that been done?
That, Judge, I've spoken with my client about it after going through all the transcripts again, all the arguments, all the motions, the court's ruling, and going through case law out of the first DCA. First DCA treats these as though a writ on this type of issue, the stand your ground issue, is similar to any other writ of prohibition for like speedy trial or something like that. And the bar is so high. I don't think that's what the legislature intended. The other districts don't agree. I've got case after case after case from other districts saying that this is the preferred method to preserve it. But I've explained to my client, I don't think it'll fly with the first.
I think even the first says it's the way you have to go about it, but just the bar is a lot higher than maybe the other districts feel it is.
So
That it basically has to be, I'm doing something improperly to withhold, to keep jurisdiction of something I have no jurisdiction over.
Mr. Norris has an elderly father that he
Who was here most of the afternoon.
and so, Judge, I think if we're going to win this, I don't think we're going to win it with a writ at the first DCA. I think I'm going to have to win it at trial. Now,
I just
Mr.
want to make sure
Norris,
it's on
do
the
you
record.
disagree with that,
I
or?
was thinking that would be the proper vehicle to use, would be the writ
Yeah.
in this particular situation. And after me looking over it, I got to put a lot of trust in Mr. Williams. I mean, he's my lawyer. So I got to.
And I think one of the things, we talked about this at a previous court date, I can't remember the name of it, Rollerson, I think was the case that just came out.
Rollerson was the last one.
Just a couple weeks ago, and there's a pretty lengthy, I think it's a concurring opinion that talks about this particular issue, so.
I mean, versus the time frame in it with, still a big risk for me. I mean, even if it doesn't go good at trial, I'm still not going to be with my dad. But if it would be the proper vehicle to get this took out instead of lieu of trial, you see where I'm at?
I understand. I'm not trying to talk to you in a way that I'm encouraging or discouraging you from doing one or the other. I just wanted to make sure we talked about it, since that was what was discussed last time, that it was going to be filed. And since we're having some computer issues where everything's not updating as quickly as we'd hope, I just wanted to make sure it hadn't been filed and I just hadn't seen it.
Yes, sir.
Because it would stay the proceedings, obviously.
Yes, sir.
All right, so we've got you down for a trial date.
All right.
And we'll see you on Monday.
Okay, Mr. Norris, I'll come out and see you between now and then. Dave will probably come out to pitch you for close.
Thank you very much. God bless.
Oh, thank you, sir.
Thank you, Mr. Norris. We'll see you next week. And I think we have Ms. Creech is still left. I think you were looking up something on that, Mr.
Yes, Your
Mr.
Honor.
Sick.
May we approach on this one?
Yes.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
All right, so you have an announcement as to Ms. Creech's case?
Yes, Your Honor. The state is going to dismiss the VOP against Ms. Creech.
Okay, does that terminate her probation?
And, well, we would ask that her probation be terminated unsuccessfully.
Russell?
Judge, I would just ask probation, does that end her case with y'all? Probation is terminated?
Is she past her date?
But if the state terminates the probation today and the court orders it, that'll be the end?
Just no. No, I'm talking deputy.
I'm 18 months from October last year. State's announcing a dismissal of the VOP based on what we discussed at the bench. The court's going to terminate her probation unsuccessfully.
Thank you, Your Honor.
Is there anything else holding her?
I do not know the answer to that, Judge. Is there anything else holding you?
No.
Okay.
All right, thank you.
Jay, how do you feel?
Thank you, Judge.
hold on a second. Ryan Messenger, he's an out-of-state fugitive. He's been released. I saw that.
Oh, okay. Then if that's the case, the state would like to dismiss those charges, Your Honor.
Mullis? See that. Under Miss Rivers? Jared Mullis. Is he back there?
Not on the transport list.
Yeah, he bonded out back in May.
You want to pass it to Monday, and I can let Miss.
I'll put it on Monday if y'all can track him down, but, technically this is his court date and he's bonded out and he didn't show up.
I'm looking in stack and I'm seeing that Lisa filed a waiver of appearance on 6/13.
Well, there you go. See that, and just to point that out, that's 11 days.